Well, a showdown between the Senate and the Supreme Court over ethics, but only one party even bothered to show up. Senate Democrats holding a hearing over why the High Court isn't bound by a code of ethics commonplace among lower courts and elected officials.
It follows reporting on undisclosed real estate deals by two justices and Chief Justice John Roberts' refusal to testify. Caitlin Burke is following the developments and has tonight's top story. Caitlin?
In the past month, reports involving two justices opened the door to these questions. A ProPublica investigation found a Republican billionaire paying for luxury vacations for Justice Clarence Thomas over the last 2 decades. He also bought real estate from Thomas in Georgia. Neither were disclosed. Then last week, a Politico report that Justice Neil Gorsuch didn't disclose he sold property to the head of a law firm with multiple cases before the Supreme Court. Democrat lawmakers call these ethical violations and want legislation passed to hold justices accountable.
Because the court will not act, Congress must.
During Tuesday's Senate Judiciary hearing, Democrats pointed out that the High Court is the only federal court without a formal structure of ethics.
Justices read the ethics rules in unique and eccentric ways. And when they're caught out of bounds, they refuse to allow any investigation of the facts.
While Republicans agree for the need of greater transparency from the High Court, they accuse Democrats of attempting to delegitimize the justices rather than bring about reform.
The danger isn't that rogue justices are operating without ethics. It's that Democrats aren't winning every fight, and they find that reality intolerable.
If you want to talk about making the court a better institution, I'll be glad to work with you in that regard. If you want to talk about destroying the court, count me out.
Chief Justice John Roberts declined an invitation to testify, citing concerns about separation of powers and suggesting it could threaten the independence of the judiciary.
The constitutional separation of powers means that no branch of the federal government can dictate how another should govern itself.
Answering legitimate questions from the people's elected representatives is one of the checks and balances that helps preserve the separation of powers.
In response to the hearing, all 9 justices released a joint statement explaining their commitment to ethics principles while dismissing calls for oversight. Still, Democrats have introduced several bills that would require the Supreme Court to adopt an ethical code, consequences for violating it, and recusal guidelines. Expert witnesses, however, disagree on whether Congress has the power to do so, given the Constitution deems the judicial and legislative branches as co-equal.
It is the Supreme Court, not the Congress, that has the prerogative under our constitutional structure to decide whether to adopt a code of conduct that governs themselves.
For over 230 years, and for as long as the Supreme Court has existed, Congress has regulated vital aspects of its operation, including its ethical obligations.
It's unlikely any of the proposed bills will make it through a divided Congress. But as one expert witness pointed out, even if a law did pass with bipartisan support, Congress can't compel the Supreme Court to abide by it. John, Jenna?
All right, Caitlin Burke, thank you very much. And here with us now is Thomas Chipping, Senior Legal Fellow at the Heritage Foundation. Thomas, welcome. So let's start there with the question of authority. Even if Congress were to impose ethics rules on the High Court, couldn't the Supreme Court just turn around and deem them unconstitutional?
Well, they could, but the real question is the distinction between Congress imposing some ethics rules and Congress requiring the Supreme Court to do so. That may seem like a kind of a trivial distinction to many, but it is a very important constitutional distinction. One thing that the Democrats on the committee today did not acknowledge was that they had asked for the views of one of their favorite liberal law professors, Larry Tribe from Harvard Law School. And in his letter, he said Congress does have, in his opinion, authority to impose some rules, but he flatly rejected as a violation of the separation of powers, Congress requiring the Supreme Court to do so. And that's what all 3 current Democratic bills would do. Congress does not have the authority to do that.
Thomas, notwithstanding the separations of power argument, only a quarter of the American public has confidence in the Supreme Court, according to recent Gallup polls. That's down some 40% from a couple of years ago. How does that factor into the equation when it comes to the need for greater reform and transparency?
Well, of course, a poll like that by itself, which is so general, doesn't give any indication as to why people have confidence or why they lack confidence. You know, confidence in the Supreme Court can be undermined or manipulated as well. The left and Democrats in Congress have had a relentless campaign criticizing the current Supreme Court as partisan, unethical, ideological. You had Chuck Schumer, the Democratic Senate leader, on the steps of the Supreme Court a few years ago, threatening individual justices if they didn't rule the way he wanted. So that erodes confidence as well. This isn't just an organic, you know, people just know everything about the judicial system, they observe what's going on, and then they have an opinion. No, people's confidence and perception of the Supreme Court is easily manipulated,
Thomas,
and that's part of this campaign.
If I may interject, though, lower courts have these code of ethics standards, so why not the Supreme Court?
Well, the Congress created the lower courts, and so Congress has much more authority to regulate them. The Constitution, however, created the Supreme Court. So Congress's authority over the Supreme Court is not the same as it is over the lower courts. And in fact, the code of judicial conduct that the lower court judges follow is not mandatory. It's only guidance. And the Supreme Court justices use the same code for the same guidance. So, you know, none of those things were mentioned by the Democrats today, but there is a fundamental difference in terms of Congress's authority over the lower courts and over the Supreme Court.
Hey, Thomas, in the time we have left, today marks the one-year anniversary of the Dobbs leak, revealing the Supreme Court's decision to overturn Roe. Justice Alito said over the weekend he had a pretty good idea of who it was, and the leak made the justices what he called targets of assassination. A quick final thought.
Well, I think he's right. The leak was clearly by someone who wanted to manipulate the court's opinion. It clearly didn't work. But it certainly added to what I was talking about before, and that is the degrading view of and perception by the public, and that results in some very, very dangerous consequences.
All right, Thomas Chipping of the Heritage Foundation, thank you so much for your time and insights tonight.
Thank you.